This is an ABC News special report.
Good morning, I'm Whit Johnson in New York. We're coming on the air because the Supreme Court has just issued a ruling involving hundreds of people convicted for their actions during the January 6th attack on the U.S. Capitol. Justices weighing whether to reverse the convictions of hundreds of January 6 rioters charged with obstruction under a 2002 financial crimes law applying to evidence tampering. The case brought by former Pennsylvania police officer Joseph Fisher, who entered the Capitol on January 6 and was charged with obstruction of an official proceeding. Moments ago, the court limiting what charges can be brought against those January 6 defendants. Let's get right to ABC's senior national correspondent Terry Moran at the Supreme Court. So, Terry, break down what this decision means.
This is a potential win for this defendant, a man who stormed the Capitol on January 6th and was charged with this obstruction of an official proceeding crime. And for those other defendants, perhaps even including Donald Trump. I want to say potential because how this is applied matters. But here's the bottom line. This law, as you say, was originally written to address financial and business crimes passed in the wake of the Enron scandal. And the first part of it says that whoever alters, destroys, mutilates, or conceals a record, a document, or other object, and then it says, or otherwise obstructs an official proceeding. And the question was, is this crime, are these crimes limited to documents and records, as the first clause suggests, or does the otherwise say any kind of obstruction of an official proceeding, including storming the Capitol, counts? In a 63 opinion written by Chief Justice John Roberts, Roberts says you can't transform this statute that has to deal with documents and business crime and the like into an all-purpose catch-all obstruction of justice, obstruction of official proceedings count. So it's a win for Mr. Joseph Fisher, the man who stormed the Capitol and brought this case. It seems, because the question is, does that get him off the hook? Does it get Donald Trump off the hook? And there is a possibility that in storming the Capitol, they interfered with the process of documents, the electoral count votes that were being certified that day. That's a question for the lower courts. But the court has essentially shut down what the special counsel and the Justice Department was trying to use this law for, obstruction of official proceeding, to use it to apply in general to anyone who stormed the Capitol. That can't be. It has to be tethered to documents, records, and the like, just as the first part of the law says.
Terry Moran for us, thank you. Let's also bring in ABC's senior Washington reporter, Devin Dwyer. And Devin, I know Terry was talking about those 300 defendants, those January 6 rioters, but also, what do we know about what this could mean for former President Donald Trump?
Well, with 2 of the 4 charges against Donald Trump in the election interference case that Jack Smith has been assembling involve this particular part of the law, 1512C2 in that financial law that Terry was just talking about. And so there was real concern here that if the Supreme Court would throw out this particular charge against January 6 rioters, that it would mean Donald Trump, half the case potentially about Donald Trump could get tossed out or invalidated. That is not the case here. This decision by the Supreme Court is very measured. It's narrow. It's basically laying out, as Terry just said, that anytime those charges are going to be brought under that part of the law, there has to be some connection to documents and records being destroyed. That's still very much in play. So should the special counsel be able to proceed in his prosecution? And that's an open question. We'll hear from the Supreme Court on Monday whether Donald Trump has immunity or whether this can go forward. Special counsel Jack Smith will have to show very specifically that obstruction is linked to documents and records.
Yeah, that big decision on immunity is still to come. Let's go ahead and bring in ABC News Supreme Court contributor Kate Shaw. And Kate, this might be confusing to some of our viewers because we're talking about the interpretation of a 2002 financial crimes law in the wake of the Enron scandal. But help us understand more about this decision and what we heard from the justices.
Sure, Whit. So, right, the law was passed in response to the Enron scandal, which involved, among other things, document destruction. But the question here is the statute limited to the context of destroying a document, or does it have broader application? The Justice Department took a look at the statute and said it criminalizes otherwise obstructing or impeding an official proceeding. That is broad language, and it applies to individuals who sought to obstruct the counting of electoral votes to certify Joe Biden as the winner of the presidential election. So they thought the statute actually did cover this conduct conduct, and so they went forward with the charge. What the court here says is you have to look both at the context in which this law was passed, but also surrounding language, which makes reference to documents and records. And again, it's not that prosecutors could never charge, storming the Capitol under this provision of law, but there needs to be, again, a connection to the destruction of records and documents, not just, blocking a proceeding. And that will be the question, among other things, about whether, assuming, there's a prosecution that can go forward against former President Trump. Again, we're still waiting for the big immunity ruling. But 2 of the 4 charges, as Devin was saying, come from this statute. So the prosecutors, I think, assuming they can go forward, will have a tough decision whether to try to show that these 2 charges can still succeed against former President Trump after this ruling, or potentially they just drop those 2 in the interest of time and, kind of streamlining the remaining 2 charges, one about defrauding the United States and one about depriving citizens of rights, including the right to vote. So they're, I think, going to have a weekend pouring through this decision to decide how to proceed, if at all, using these 2 charges.
Yeah, some difficult decisions going forward. Kate Shaw, thank you so much. Let's bring in ABC's Chief Justice Correspondent Pierre Thomas. So, Pierre, how is the DOJ likely to respond to this? I know that the number of defendants here is relatively small in terms of the scale of all those who've been charged.
Well, we've been having conversations with sources within the Justice Department to get a sense of what they were anticipating. Obviously, they will be disappointed that the Supreme Court chose to make the ruling that they did. And they know that Donald Trump and some of his supporters will use this as a symbol of government overreach. That said, they're out with numbers that suggest they believe will prove that this has a limited impact, that the number of people actually affected by this ruling is very small. There were 300 and some odd suspects charged and convicted under this particular statute. DOJ is saying that the overwhelming majority of these people had other charges attached to their case, meaning that they would still serve prison time, and they conclude there are only about 27 people that had only this case as the primary charge against them, meaning about 27 people would actually see some likelihood of their sentence being significantly reduced.
All right, Pierre Thomas for us, thank you. ABC's senior congressional correspondent Rachel Scott is also joining us. Rachel's been out on the campaign trail. You were at the debate last night. You were also at the Capitol on January 6th and witnessed this riot as it played out. But how do you think this is likely to play politically for both the Biden and Trump campaigns?
When I was there on January 6th, from the moment the rioters stormed the Capitol, watching police being outnumbered and overwhelmed. Now, 3 years later, the former president has really brought this to the center of his campaign. He has promised to pardon the rioters who stormed the Capitol on January 6th, calling them hostages. Often on the campaign trail, he plays music of rioters who are behind bars singing the national anthem, who stormed the Capitol on January 6th. Even last night on the debate stage, the former president standing by his actions that day. It's a big reason why the Biden campaign is insisting that Donald Trump is a threat to democracy.
All right, Rachel Scott, thank you so much. We appreciate it. Once again, the Supreme Court with another major decision limiting what charges can be brought against the January 6th defendants. We're going to now return you back to regular programming. For some of you, that's Good Morning America. And then our coverage continues on ABC News Live and abcnews.com. And I'll be right back with the entire World News Tonight team later this evening. I'm Wade Johnson in New York. Have a great day.
This has been a special report from ABC News.
Hi, I'm Diane Macedo. We have some continuing coverage now of the Supreme Court's decision making it harder to charge January 6 defendants with obstruction, a charge that also has been brought against former President Trump. The justices ruled the charge of obstructing an official proceeding must include proof that defendants tried to tamper with or destroy documents. Only some of the people who violently attacked the Capitol on January 6, 2021 fall into that category. The charges stemmed from a 2002 law enacted to prevent the destruction of evidence in financial crimes in the wake of the Enron scandal. The justices determined the language in that law that includes trying to impede an official proceeding did not apply here. Let's bring in ABC News senior national correspondent Terry Moran, who's outside the Supreme Court, along with ABC News Supreme Court contributor Kate Shaw for more. Terry, how significant is this, and what do you make of the justices sort of threading this line, saying you can charge some of these suspects, but not all of them?
Well, they're reading the statute very closely. That's what this is, reading the law very, very closely. This case brought by one of the January 6 defendants, a man who stormed the Capitol and was charged, like many hundreds of other people who did that, with obstruction of an official proceeding. And he brings the case saying that he's been improperly charged by prosecutors because that law, he argues, was written to address financial and business crimes after the Enron scandal. And his lawyers point to the language in the first part of the law that says anyone who alters, destroys, mutilates, or conceals a record, a document, or other object, or otherwise, and this is the part of the issue, obstructs an official proceeding. That phrase, obstruction of official proceeding, is what Donald Trump has been charged with and many of the January 6th defendants. And his argument was it's a business crime. It's supposed to be tethered and tightly bound to document destruction, tampering with documents and records. And in this case, in an opinion by Chief Justice John Roberts, vote of 6-3, the court says he's right, that this kind of law cannot be used as a catch-all obstruction case. What Chief Justice Roberts says is that the court can't transform this evidence-focused statute into a one-size-fits-all solution to obstruction of justice. And so he goes on to say that to prove a violation of this law, the government must establish that the defendant impaired the availability or integrity for use in official proceeding of records, of documents, or objects. Now, does that get Mr. Fisher off the hook? Does it get Donald Trump off the hook? Not necessarily, because as Justice Ketanji Brown Jackson, who joined the opinion, says, well, storming the Capitol was an attempt to interfere with an official proceeding on documents, the records of the Electoral College vote. And it is a question now for the trial court in all these defendants' cases to see if that theory holds weight under this opinion. But it is certainly a partial win for the January 6th defendants, including Donald Trump.
And I want to bring that point to Kate Shaw, because, Kate, as Terry points out, the big part in question here is this sort of catch-all phrase at the end of the law that says otherwise obstructs, influences, or impedes any official proceeding. So what do you make of the justice's argument here that that doesn't now mean any time someone tries to impede an official proceeding that this charge can come into play? And what do you think the impact could be on former President Trump and the defendant in this case?
Well, Diane, it certainly narrows the possible kind of universe of conduct that this statute could be used to target. And it pulls this document reference from the preceding part of the statute and says that informs the meaning of this otherwise broad language that just says otherwise impedes or obstructs an official proceeding. Again, so there, as Terry was saying, there needs to be some nexus to document destruction or impairment. But it is certainly possible, and maybe to take the former President Trump question, it is certainly possible. So former President Trump was charged by the special counsel in the election interference case, which is, of course, just one of the cases. But in that case, there are 4 charges, and 2 of them are the same charge at issue in this case. And so it may be harder for special counsel Jack Smith and his team to successfully proceed with those charges, assuming the Supreme Court allows that proceeding to resume at all after the immunity decision, which we are still awaiting. But it may be that Smith and his team are able to say there are documents at issue in this case, and those documents are the certificates certifying from the state certifying Joe Biden as the winner of the presidential election, maybe even the conduct related to the assembly of fake elector certificates. Those 2 are documents, and that is part of the alleged kind of criminal conduct at issue in the January 6th prosecution against former President Trump. So this case, I think, leaves the possibility of reframing some of the prosecution against Donald Trump, but it'll be a question of whether Jack Smith's team believes there's time to do that in this case. Of course, there's not a lot of time left before the November election.
And I want to bring in Chief Justice Correspondent Pierre Thomas for more on the larger impact here, because, Pierre, this isn't just about former President Trump. There are lots of other January 6 defendants here. What does this mean for them and for the plaintiff here, Joseph Fisher?
Well, DOJ has been, giving out some guidance, and we have some numbers from them. Look, they're pointing out that over 1,000 January 6 defendants have been charged and convicted. And they make the point that many of them have been convicted of other felonies in addition to this particular statute. Their argument here is that this statute only applies to roughly 300 of those 1,000 plus suspects that were charged, and that of that number, only a tiny percentage had only that charge as the primary charge that they were convicted on. And in their data that they're putting out, only about 27 people in their mind would have the potential of their sentence being significantly reduced. So that is their bottom line, that the practical impact on this is low. But they're well aware that former President Trump and his supporters will point to this as government overreach and that they were overzealous in some of these prosecutions. But their bottom line is that this affects a relatively small number of people. The overwhelming majority of the January 6th suspects, many of them were charged with violent acts, are not impacted.
And Terry, Justice Amy Coney Barrett wrote this blistering dissent in this decision. What stood out to you there?
Well, the fact that she joined the liberals. This is an unusual case. Justice Ketanji Brown Jackson joining the conservatives with the narrow reading of the law, and which essentially has the potential of helping January 6th defendants. And Justice Amy Coney Barrett, appointed by President Trump, writing the court's dissent, saying the court got it wrong, and that essentially what the Congress wrote in that very broad language, otherwise obstructs an official proceeding, should be read, that text, just as it means, just as it's written, and apply to any kind of obstruction like storming the Capitol to stop the electoral count vote. And so it is interesting. And she says, she criticizes Chief Justice Roberts' opinion. Roberts saying, well, look, it says records and documents and all these other physical things. And what Justice Amy Coney Barrett's response to that is, why does the court hold this way? Because it simply cannot believe that Congress meant what it said. She says, this law is a very broad provision, and admittedly, events like January 6th were not its target. She says, parentheses, who could blame Congress for that failure of imagination? Essentially a sharp criticism, obviously, of what happened that day in justification of her saying these people should be held to account, including Donald Trump, under the law that provides for corruptly obstructing an official proceeding. That's not going to happen, it seems, given the Chief Justice's opinion. But it's very interesting that one of Trump's own appointees sided with the liberals.
And Kate, I'm out of time, but quickly, what does that tell you about a court that's sometimes criticized for being too partisan, to see Amy Coney Barrett siding with the other liberal justices and Justice Ketanji Brown Jackson siding with the more conservative justices here?
I think most of the votes this term are still going to fall along predictable ideological lines, but I do think that Barrett in particular is showing that she's quite an independent thinker, and I expect her to join the Democratic appointees perhaps more frequently. And Jackson herself is a former public defender, and so reading a criminal statute narrowly is something that isn't necessarily surprising from her, but it is a good reminder that they do not always fall along predictable 6-3 ideological lines. And of course, everyone is now waiting to see how that plays out in the immunity case, which is the really enormous case that we continue to await at this late date in the Supreme Court's term.
All right, and we will be watching closely for that one. Terry Moran, Kate Shaw, Pierre Thomas, thank you. Coming up, President Biden and former President Trump face off for the first time in 4 years. We have the reaction and the fallout from the first presidential debate.
Whenever news breaks,
we are here in Israel, a nation at war after that brutal surprise attack by Hamas.
On the ground in Ukraine, reporting from Lewiston, Maine.
The scene of a horrific mass shooting.
ABC News Live is right there everywhere.
From the scene of that deadly missile strike in Dnipro, Ukraine,